Good morning.
Dimitri Blitzen, Your Honor, for the draft law.
I think you're with the Island County now.
Island County Democratic Central Committee PAC here.
Thank you. So we are here on the plaintiff's defendant's motion to dismiss. The papers were stacked incorrectly. I'll indicate that I've reviewed everything that's been submitted associated with this. I will also indicate that I will not be swayed by accusations of the weaponization of campaign finance laws in Washington State or any sort of partisan allegations whatsoever. They are irrelevant to the issues the court is to decide this morning. So if we could focus solely on the statute and not focus on either that or any factual allegations regarding the volunteer nature and lack of experience of the individuals associated with this. Simply put, we have some very discrete but interesting legal questions that are to be decided on this motion. It is the defendant's motion, so I'll hear from the defense first. My first question to you is, we really have no guidance in Washington State about what to do in these circumstances, is that correct?
So actually, Your Honor, I was looking at this stuff again yesterday. Dimitri Blitzen, Shrink, Helen Bernardi Blitzen, not with me is Lori Ewan. I actually think that this, as you said, there's a very discrete legal issue here, and we do have guidance, and that is on the priority of action rule argument. And I actually think that this case is most easily disposed of.
And that's the Washington Education Association
It's
case?
actually the Yakima, the firefighters versus City of Yakima Supreme Court decision and the WEA, the Freedom Foundation versus WEA case. And if I can just address those very simply. In the firefighters versus Yakima case, the firefighters filed a charge with PERC, Public Employment Relations Commission, an administrative agency, against the City of Yakima. The City of Yakima then filed in the Superior Court for a declaratory ruling on the same issue.
So the characteristics of PERC are such that upon filing of a charge, a case is it effectively started. Isn't that the way that PERC works? The adjudicatory functions of PERC, those wheels start turning once you file a charge, right?
Correct.
And that doesn't happen with a PDC complaint.
Right, which is why, but I think we need to look at the two cases in order. Certainly to answer your question, the facts of this case are not exactly the same as either of those. But the concept of the Yakima case is both PERC and the Superior Court have concurrent jurisdiction. And the Supreme Court ruled that in that case, because the dispute was first submitted to PERC, PERC had jurisdiction, or retained jurisdiction, as opposed to the Superior Court under the priority of action rule. Well, the reason I'm emphasizing this is that there's been some suggestion, well, look, the statute says this court has jurisdiction over citizen suit. That's true. But the question is, when two entities have jurisdiction, who gets to keep it?
And those jurisdictional wheels are turning. I mean, that really,
Right.
This is as if King County Superior Court and Thurston County Superior Court both had cases.
Right.
There's things going on.
So
But here we have a PDC complaint.
But so that's where we get to the WEA, the Freedom Foundation versus WEA case, where, since we were talking about an amended allegation about money from MEA to WEA, the Freedom Foundation in that case, interestingly, filed its complaint with the Attorney General. The Attorney General referred it to the PDC. And all we are told in the case at 111 Washington Ave 604 is the PDC took an administrative action. I'm sorry, I need to go too fast. In the case, all we are told is the PDC took an administrative action based on the allegation. The AG refers it to the PDC takes an administrative action. Then when the Freedom Foundation seeks to add this as a claim in the Superior Court lawsuit, the Court of Appeals says no. The PDC, by having had the case referred to it and taking an administrative action, retains exclusive jurisdiction under the priority of action. Now, the facts of the instant case are much more compelling even than the facts of the EFF versus WEA case. Because in that case, the Freedom Foundation did not go to the PDC at all. In that case, the Freedom Foundation actually went to the AG, and the AG handed it off to the PDC. In this case, Mr. Morgan filed a complaint with the PDC.
In the Washington Education Association case, wasn't there an indication that the PDC would file administrative charges against?
There was a letter from the AG to EFF saying the PDC is going to. There's nothing else in the decision that I see indicating that that had happened ever or specifically before the ruling. They didn't say because the PDC filed charges.
So what's the administrative action that's being referred to?
I don't know. But I know in our case, the PDC initiated an investigation.
Do they ever not send that letter out to people when complaints have been filed?
So that's not in the record. I would say that, especially in the last couple of years, it's kind of a new world with literally hundreds of complaints that have been filed. And I will represent that, I think it'll be undisputed, that this approach of Mr. Morgan filing a complaint with the PDC and then forwarding it to the AG has been his practice. So everything is landing on both the PDC and the AG's desk. To me, what is significant, what makes this easy, recognizing I don't know what the administrative action was that the PDC took, although we can infer that it wasn't the PDC has brought a civil suit in a superior court, or surely the court would have noted you have two courts and two proceedings. So it was something less than a suit. Could, I suppose, have been some kind of notice of citation or intent to do something, but all we know is it was administrative action. But I think it is significant, since the point of the priority of action is that something's called a choice of forum kind of thing. In this case, Glen Morgan chose the PDC. He chose it first. He chose it at least 2 months before this lawsuit was brought. And we know that the PDC commenced an investigation. I will again represent to the court that when a civil suit is filed, the agency typically stops spending its resources on it. It knows that it's in another place. Hasn't closed that investigation. There's no question that if this case is dismissed, that
Are you aware of the PDC taking any action other than forwarding the complaint and asking for a response?
I don't remember. There might have been a little bit of back and forth email, but certainly nothing substantive, no filing of, the PDC did not bring a suit. I'm not sure what else it might have done. But it is our position that the combination of Glen Morgan filing a complaint with the PDC and the PDC taking the action of initiating an investigation is an adequate assertion of jurisdiction by the PDC if such action is necessary, that it is appropriate and equitable and consistent with both the Yakima case and the WEA case, that this court should decline jurisdiction in favor of the PDC. And again, while it is true that in the Yakima case, the firefighters had filed an unfair labor practice charge, there's no evidence in the Yakima case that that charge was processed. That here, as I recall, I'm pretty sure I'm stating the facts, I don't recall any evidence that. So the first step in a PERC charge is PERC has to do a preliminary determination of whether the charge has enough possible merit to state a culpable thing. I don't remember there being any evidence in the Yakima case that PERC had done any of those things. The Supreme Court simply said, you know, a charge was filed with PERC. They didn't actually say PERC has taken an action. Now, I agree with you. One could know from the regulations what PERC would do, but I don't respectfully think that the test is, has the administrative agency taken an action such that would allow us to say, well, if the administrative agency had filed a citation, then it has jurisdiction. And there's a, versus if it just starts an investigation. Here's the problem with that. It creates a completely undeterminable line. So for example, I file a complaint with the PDC. PDC says, we are starting an investigation. That investigation would tend to have a lot of back and forth, might have discussions about settlement before filing a citation or something. Unless the rule is, if you submit a complaint with PDC, you've elected your forum and the PDC takes precedence over Superior Court.
Is that your forum? Are you a party once you file the PDC complaint like you are in PERC? In PERC, you're a party vis-a-vis the other side. In the PDC, is it your forum?
No, I mean, I wouldn't normally characterize it that way. It's an administrative agency. I understand the distinction you're making with PERC, and that's one of the places where I get to practice. But that gets back to the WEA case, which clearly wasn't troubled by that. If WEA could have said, well, that's a different kind of process than PERC, and therefore we're not going to apply the party of action rule. WEA says PDC, not the charging party, but PDC. I mean, I guess what I'm struck by is in the WEA case, the complaining party had never asked to have its case heard by the PDC. They sent a letter complaining to the AG, and the AG referred it to the PDC. And the Court of Appeals still said, you know, it's at the administrative agency now. Frankly, you could make equitable arguments about choice of forum that would have been much stronger in the Court of Appeals case, in the WEA case, where Freedom Foundation could have said, but we never wanted it to be an administrative agency. Getting back to what I was saying before.
So the priority of action doctrine states, the forum that first gains jurisdiction over a matter retains exclusive authority over it.
Right.
Is the act of a citizen filing a complaint some jurisdictional moment where it spreads jurisdiction pixie dust on them, or couldn't the PDC of its own volition investigate or become aware of something to take enforcement action?
This is exactly what the WEA case holds, because in that case, nobody filed a complaint with the PDC. The Attorney General referred it to the PDC. The PDC, I suppose, could have said to the Attorney General, we don't want it.
So what's the moment that the forum first gains jurisdiction?
When some entity, apparently not just Glen Morgan, but even the AG, when somebody hands it to the PDC prior to a lawsuit being filed in the Superior Court, then the PDC has jurisdiction.
So the passing of the baton, so to speak, is the passing of jurisdiction.
Well, I mean, to me, it's interesting. There was really a passing of the baton in the WEA case from the AG. It was, as I say, the facts are simpler in this case because the baton was just, I mean, the starting gun was simply a complaint to the PDC. I think that the only line drawing that makes sense to say, and it's, again, easier in this case, is if you file a complaint with the PDC, you have signed up for the ride with the PDC. You can't file a complaint with the PDC and 2 months later file a suit in Superior Court. And if we think about the social policy, the reasons for it, we don't want people, frankly, to do what happened. We don't want people to be filing complaints both with the PDC and the AG, having a PDC spending resources, investigating, potentially bringing an action, simultaneously having the Attorney General possibly bringing a lawsuit or a citizen's suit. That's precisely what the priority of action rule is supposed to prevent. Again, the facts here are easier and more straightforward than the Court of Appeals in WEA, where at least the Freedom Foundation has said, but we only wanted one forum, the state and ultimately the court. In this case, Glen Morgan chose to submit his complaint to the PDC. And therefore, I don't think there's any injustice under any analysis saying, yes, the PDC then received or exercised, if one wanted to say, well, there had to have been some affirmative action by the PDC that would sort of perfect its acceptance of jurisdiction. And there's some suggestions in the cases that that might be an appropriate line to draw. Then initiating an investigation is clearly across that line. And I would submit that it's impossible to draw any other line, because you don't want to say the PDC could investigate and negotiate and all these things, but if 6 months later it hasn't yet filed an action, an enforcement action, it still doesn't have jurisdiction in the Superior Court could move ahead. That's clearly bad policy that's not consistent with the case. As I say, all I see in the WEA case, and maybe I'm missing something, is the PDC took an administrative action. But I don't even see that in the Yakima case. I don't see that PERC took any administrative action in the Yakima case, even if one might posit that it would have. The analysis could have been in the Yakima case. Firefighters filed a charge with PERC. PERC has so far done nothing. Let us posit that PERC has not even issued a preliminary ruling. And now the city of Yakima has filed a lawsuit for declaratory judgment. The Supreme Court in Yakima could have said, well, PERC hasn't done anything yet, so the city gets to go to Superior Court. But it's actually the facts of that case are so interesting because what was really happening, the firefighter said, we want this resolved by an administrative agency. And the city said, we want it resolved by Superior Court. And all the Supreme Court did was said, firefighters got there first. They got to PERC before the city got to Superior Court, both at concurrent jurisdiction. They didn't say, well, because PERC has acted, because PERC has geared up some kind of fact-finding procedure or hearing, they just said, you know, sort of race to the courthouse administrative agency. In this case, Glen Morgan raced himself to the PDC. He did not have to file a complaint with the PDC to sue Island County PAC in Superior Court. He could have simply filed a complaint with the AG, and if the state did not sue, then he could have brought this suit ex rel the state. So I don't want to belabor those points. I think I've made my argument clear.
Are we still maintaining the argument that the solution is meaningful in this case?
Absolutely.
Okay. And then what's the position regarding attorney's fees?
Well, I
Do
think
you believe that the court doesn't, it would be inappropriate for the court, even if the court were to say that fees cannot be directly awarded against the defendant, to maintain the issue of attorney's fees in this case to assess the reasonableness? Do you think that would be inappropriate in this case?
Well, I think that there's probably a necessary party if the plaintiff were to prevail and be entitled to attorney's fees under subsection 4 from the state. If I were the state, I'd go, wait a minute, Your Honor, before you assess attorney's fees against us for reasonableness, I would think that the state would be a necessary party. I didn't argue in this case it should be dismissed for lack of necessary party, because as are the cases, there has to be a certainty that you're going to get there. I expect that we won't. I think it would be useful when this case goes up on appeal to have Your Honor address the attorney's fees issue, even though I'm quite convinced that we should win on both the priority of action rule and the fact that, I mean, I was about to introduce myself as, it's a little odd, I got paid by this PAC before it went out of business. There was an understanding that I would do what I could to sort of make sure their name wasn't, you know, dragged through the mud. But they don't exist anymore. And I don't understand, as I said in the pleadings, I actually literally don't understand what would happen next if you did not grant the motion to abate, because the money's long since run out. I'm not going to be responding to discovery for a defunct entity, and a judgment against the defunct entity is not collectible. And there's that FEC case, that federal case, that reached exactly that holding. You know, if it's defunct, it's just, you can't do it. There's no point in doing it. But as I literally don't understand. I frankly don't understand. Apparently, there's, you know, we've cited statutes that, by statute, the state has changed the rule about corporations, and you can sue a defunct corporation. I don't actually understand how that would work either, but it might be bankruptcy, there might be some other theories of collecting from related entities. But the common law seems very clear. You can't sue a defunct entity. To me, that's only logical. And I just want to be clear, there is no theory that people who donated money to this PAC when it was operating, or even the officers of the PAC, they were not named in the 45-day letter. They are not sued in this action. There is no theory that individuals who take part in a political committee have personal liability for the wrongdoings of that committee. You can scan 25 years of PDC findings and AG actions. So absent that kind of a theory that in this case, anyone is sued but this PAC, and given that the PAC filed its terminal C4, it shut down, it has no money.
Well, and how does the termination mechanism actually work? Do they just file the terminal C4 and it's just done, or is there some additional action from some other entity?
No, there are certain prerequisites. They have to have zero money left, and there are a couple of other record-keeping things, and then they file, just like you create a PAC by filing certain documents, C1PC, say, we want to be a political committee. And then you are obligated, serious obligations to report timely and properly. And then you file the terminal C4, and you don't exist anymore. And I do want to say, because I do a lot of political work now, I'm hired by a ballot measure committee that has a measure on the ballot for November of 2018. And it had never occurred to me, it still doesn't, if November 18 comes along and they win and they lose, and they have spent every last penny trying to win the ballot in November, and I send them a bill and they say, we don't have any money left, we've shut down, it had never occurred to me that I could sue somebody like the then no longer extant ballot measure committee. Well, you have to pay me. Like, if I'm foolish enough to not get the money up front, I'm not going to get paid.
So what if they violate every campaign finance rule as they go along and dissolve on election day? Is there no need?
So there are situations where the PDC, and I'm thinking of a case with a company called Moxie Media a couple of years back, where the PDC, actually the PDC worked at a agreed settlement, and then the commission rejected it and went to the AG and they sued. And they sued the principals of Moxie Media, saying, you intentionally designed an unlawful scheme that would hide the source of campaign contributions. So there could be a theory, if there was any evidence or allegation, for example, that somebody in fact created this PAC with an unlawful, or even while running the PAC, unlawfully, intentionally violated the law. They're both criminal and civil actions that could be taken against those people. But that is not the allegations Glen made. His allegations are solely against the committee, qua committee. I hardly ever get to use that word, qua. And there are, the current campaign finance laws are replete with provisions that could be the subject of meaningful discussion about whether this law works, quite frankly. In fact, it's probably no surprise to you to know there's legislation being argued about in Olympia as we speak that would amend this law. There are lots of things about it where one could say, well, that doesn't seem like it makes a lot of sense, and which the response is going to be, well, it's kind of for the legislature to fix. Now, to be fair, for 22 years, there has not been, to my knowledge, a situation where a committee was alleged, for example, by the AG to have violated the law and then went to funds. And the AG went, well, what do we do now? That issue would have perhaps been brought to the legislature years ago, if it had happened years ago. So you can say this law has actually worked effectively for however many years it's been since the initiative was passed. That apparently is not a problem. Has not been a problem. If the legislature thinks it would be a problem because of this case, so be it. But as a matter of statutory interpretation, I don't think, which is what I understand the opposing argument to be, I don't think you could say, well, that can't be what the law means because of that particular bad outcome. We can't say, well, there's no other remedy. And as I say, the most obvious example is if there was any evidence of intentionality, there are other remedies that the AG and the PDC would have. So we're dealing with a pure situation where a political committee allegedly disputed, failed to meet the somewhat arcane filing requirements of the Fair Campaign Practices Act, and run out of money, doesn't have any way of, realized it didn't have any way of getting more money, and I'm trying not to get into those facts, but in fact, it had no money, and it shut its doors. I think the burden is on the plaintiff to suggest that the legislature, the initiative and then the amendments somehow intended there be some follow-up step against a defunct committee. And because, as I say, I can't even think of what those follow-up steps would be, other than them obtaining ultimately a default judgment and then asking you to impose a penalty on the committee. And then you have to decide, well, I'm imposing, am I really spending the time of Thurston County Superior Court imposing a $3,000 fine on what used to be the Island County Democrats political committee that doesn't exist, that no one's ever going to pay? To me, it's not very irrational to say if the committee doesn't exist anymore, then the lawsuit should be paid.
Thank you. I'm going to take our 15-minute morning recess at this time for the benefit of our staff, and then I will hear the other side. Court's in recess.
Thank you.
my first question for you is, why do we need to allow people to file PDC complaints when they're going to be seeking citizen actions directly themselves?
Well,
This would be a cleaner case if that hadn't happened.
it would be a cleaner case, and Mr. Morgan was actually asked by the PDC to CC his complaints that he was filing with the Attorney General's office, and he did so as a matter of courtesy. And this wasn't any formal complaint process. This was submitted through the internet portal screen at the PDC. There was no case number assigned to this, as far as I know. There's no ongoing or intensive investigation, and I think that the WEA decision, which was I think a division, either was Division 2 or Division 3, and it was a 2002 decision. I think this argument was largely laid to rest in the 2015 Supreme Court decision of Utter versus BIAW, and there a very similar argument is made. And if I could just read a small passage, the Supreme Court says, "Thus, if the Court of Appeals interpretation were correct, the PDC, a government agency, would unilaterally bar all citizen suits for violation of Title 42 just by investigating. The voters cannot possibly have intended to create a citizen's right to sue when the government will not but allow the government to bar every one of those suits with a procedural quirk."
So I think that the counter to that, playing devil's advocate as I'm wont to do here, is that it's not the act of investigating that is the issue here. It's that initial act of Mr. Morgan filing that complaint with the Public Disclosure Commission. And so it seems in that respect, the issue isn't the actions of the PDC, it's the actions of Mr. Morgan vis-a-vis his, in effect, choice of forum in this context. Is there anything in Utter that addresses that?
Well, I think if you read on, Utter has a second proposition, and that is what constitutes an action. And I cite in my pleadings their discussion of what it is that is an action, whether it's by the Attorney General's office or by the PDC. And the court goes on and says, "We decline BIAW's invitation to have the court engage in an after-the-fact analysis of whether a particular investigation was thorough enough to qualify as an action." So I think that that's speaking precisely to this case here, that, yes, the PDC was made aware of this because the PDC had asked Mr. Morgan to please, essentially CC him on all the complaints that he was filing. But this certainly doesn't constitute an action which would preclude, or we don't have any evidence in the record as it stands now that there's any action that would preclude Mr. Morgan from filing a complaint. It is clear that the Utter court read the FCPA as action being something of a much more formal process, where you actually have an administrative hearings process where they say, hey, you need to come in and we're calling you on the carpet about this, that, and the other. We don't have that here. All that we have is that the PDC was aware. I mean, it could take, there's absolutely nothing in the record which says that this will be, that the PDC will do anything with this matter.
Okay, so let's shift now, because I'm adequately, I think, versed on that issue, to the dissolution issue, more specifically what remedy is there going to be at the end of the day? Let's say I agree with you on everything else, and we have a record-breaking penalty in this case, which I'm not indicating there would be, but let's just assume. What's going to happen here in this case, given that there's nothing left here?
Well, I think let's look at what's not left here. There's only the assets were disposed of to their attorneys and to the state Democrats. Okay, and you can see that, and that was filed as an attachment to, I think it was Ms. Ewan's declaration, their final C4, and it says that, you know, essentially they jettisoned their assets to their lawyers and to the state Democrats. You know, first of all, as a matter of public policy, after you've been sued, to go ahead and then give the state Democrats your assets, so essentially you become judgment proof. That's not the issue before the court today, but I have some severe questions about the legality and the ethics of taking such an action. Remember, the instructions under the FCPA are, full transparency, honesty, that everybody's, financial transactions should be open to view, and we need to know what's going on. I don't think that the fact that a judgment may become not recoverable precludes the issuance of a judgment.
And so so that is the proposition I think that most people would agree with. We have plenty of judgments in excess of assets, and sometimes those assets are zero or negative. But with respect to an entity that arguably doesn't exist anymore, is your argument that because there was an outstanding debt or obligation, i.e. this lawsuit, that the dissolution was not effective and thus the organization is still in existence technically?
My argument's twofold. That's one part of it, is that, yes, that the obligation, which is spoken of in 235.8, I believe, that's an interesting statute because it talks about debt or obligation, and then in the final sentence it talks about an obligation to file. And we both go through and we sort of parse that using the usual statutory construction methodology. And my point essentially is that final use of the term obligation obviously means that the legislature was intending obligations to encompass something broader than financial obligation or debt, because it means that they have a duty to do such a thing. Secondly, I think that it's quite clear, and this is really more important than the statutory interpretation, is that they have an ongoing duty to report because they're still A, soliciting funds on their website, and B, we know that legal work, even pro bono legal work, is a contribution or it's an expenditure. Either they're paying for it and it's an expenditure, or out of the good graces of their heart, they're donating this, and that needs to be understood as a contribution, an in-kind contribution of legal services, and they have an ongoing duty to continue to report. So I would say,
couldn't they have prepaid for those legal services, and if this keeps going, it's just a really bad deal for the attorneys involved?
They could have. We haven't seen a declaration that says that we're going to only be paid, $4,531 or whatever it was to do this piecemeal, and we'll take this all the way through the Supreme Court, and we don't expect another dime. That could have happened. We haven't seen it. There hasn't been much in the way of declarations which would explain Whether or not this was a retainer, whether or not this was a fixed fee, we don't know. And this is a motion to dismiss. So, I don't think that that would be appropriate for the court to make that conclusion.
But most fundamentally, your statutory construction is that it still exists because you can't wind up while there is a legal charge pending against you of this nature. Is that correct? Is that your primary argument in this case?
I don't think I would characterize it as primary. I think I have a two-prong argument that says, one, you have an obligation to comply with the FCPA. Two, you're still receiving some benefits, just as if an accounting firm was helping them do their books during the time they were unquestionably performing these activities that a PAC would do. These legal donations, if they're donations, if a third party is buying their legal services, these are contributions or expenditures. I just don't know.
And who is soliciting contributions right now? Is it the PAC or is it the Democratic Party group for that county?
I wish I knew. That seems to be terribly confusing. And it's terribly confusing, especially because there is, in the FCPA, there's a rule which says that no two PACs can have the same name. Now, in the complaint, we alleged and we named the Island County Democratic Central Committee. And in their reply brief, they say, well, it's a completely different story. The Island County Democratic Committee might still be operating as an unregistered PAC, but it's not the PAC committee that was a subcommittee that had the same name that was advocating contributions and expenditures in support of political causes or candidates. Interestingly, if you go to that C4 that's appended to Ms. Ewan's declaration, it's the Island County Democratic Central Committee that signs that C4, and it is they don't sign it, but their treasurer, Mary Huffine, signs it, who is also listed as an officer on the website, which specifically says, and I supplied a screenshot of this with my submissions, that they are still actively seeking contributions to support democratic causes and candidates. So, it's sort of like, Schrodinger's political activity, political action committee. They're a committee when they want to be a committee, and then they're not a committee when they don't want to be a committee. And they can't have it both ways.
With respect to the attorney's fees issue, my read is that your position is that you are not making a specific request that the court award fees, if we were to get to that point, against the defendants, but that instead, in essence, you would want the court to retain that claim in that jurisdiction to assess the reasonableness of what you receive from the state. Is that correct?
That's correct, and I think that Section 765 explicitly deals with that issue, and it says, in any action brought under the section, the court may award the state all costs of the investigation and trial, including reasonable attorney's fees to be fixed by the court. And one of the actions in that section is a citizen's action. So the statute explicitly gives you authority to assess attorney's fees in citizens' actions by virtue of that section.
Because you're in the position of the state.
Exactly, because I'm in the situation, and I agree that if we get to that phase, then it would be completely appropriate for the state to come in and represent its interests and its opinion as to what that determination should be. But I don't think that the statute could be any clearer.
At this point, they're not a party, though, and we have a claim against these defendants, and attorney's fees isn't a proper claim against them. Isn't that correct?
Attorney's fees is not a proper claim. You can't order them to pay me attorney's fees. You can order them to pay attorney's fees to the state, and the state can then pay them to me.
Okay, so that is that indirect line that you believe is appropriate vis-a-vis these defendants. Okay, I understand your argument.
Okay.
Anything else you want to add at this point?
Not at this point, unless you have
No
any
further
further
questions.
questions.
No. Your motion, you get the last word, and I'm curious if we could start with that last point about the attorney's fees. That is interesting to me, and I'm curious your response.
I've tried to brief the attorney's fees issue. We think that's a misreading of subsections 4 and subsections 5. There are a whole bunch of stuff that applies to an award of attorney's fees to the state in a normal action, different standards that don't apply in subsection 4. And subsection 4 does not provide for an award of attorney's fees against the committee. So we continue to believe that the proper step were a citizen's suit to be successful against any committee would be for the citizen to then at least give notice to the state that it was going to be petitioning the court for an award of attorney's fees reasonable attorney's fees from the state. Then the state would then have notice and opportunity to be heard on the amount of those fees.
Understood. Anything else you want to add?
Very, very quickly, with all respect, if you look at Exhibit E to the UN Declaration, you will see a formal emailed complaint to the PDC. It is not CC to the PDC. It is a flat-out complaint to the PDC from Glen Morgan. Exhibit A is a copy of the ticket that the PDC opened and assigned it a case number as a complaint received by the PDC. If you go to that website, you'll see every single complaint filed with the PDC, regardless of whether anything was sent to the AG. And Exhibit F is the formal letter from the PDC to the committee saying a complaint has been filed, we are doing an investigation, we are soliciting your response. So I don't think it is accurate to suggest that that was some kind of ministerial thing. Glen Morgan, for whatever reason, chose to file a complaint with the PDC, and we think that that makes, as I said before, the priority of action rule argument a simpler, cleaner legal issue. I was thinking about what you said about the pixie dust, but pixie dust is an easier thing to look for when a complaint party has filed a formal complaint with an administrative agency with enforcement powers, and that agency opens the file and starts an investigation. Whatever that pixie dust stage where the agency has jurisdiction, we have passed it. And then finally, I think I explained this in the brief, but Utter was dealing with a different question. We start from the idea that there could be a PDC action, there can under certain circumstances be a citizen suit, and the citizen suit is foreclosed by an action by the state. And Utter was wrestling with, would a PDC enforcement action constitute an action as to utterly foreclose a citizen suit? And Utter, I think it's a footnote, it's not quite resolving that issue, but has some language suggesting it's skeptical of that. We are not suggesting that the PDC sending an investigatory letter means that the prerequisites for a citizen suit to be brought would necessarily not be met. We are suggesting let's assume that the prerequisite notice to the citizen has been met. We also see a complaint filed with the PDC. We have an agency and the Attorney General, both of whom are the agency and this court, both of whom the prerequisites for jurisdiction have been met. The question is which has priority, and our argument is not at all dealing with that issue, and the EFF WBA case dealt with it explicitly on point, resolving the questions when it's been started in the PDC. That precluded the subsequent attempt to invoke court jurisdiction, just the way in the Actima case, the fact that a perp charge was filed precluded the city from seeking Superior Court action, even though there's no question that the Superior Court in both cases actually had jurisdiction in those cases. There's a bunch talking about in terms of the dissolution. There is no political committee, therefore my time paid for or now being donated beyond whatever was paid for, not being donated to a political committee. There's nobody reporting it. There's no allegation that there's another entity in Island County that is now functioning as an unregistered political committee. It's all kind of on the margin stuff of accusations and counter accusations. I think the actual legal issues are simpler and clearer than that.
Anything else?
Nope.
Thank you very much.
Thank
The
you.
court is prepared to rule at this time. There are 3 issues that are pending before this court. 2 are questions regarding whether in the alternative they are bases for granting a motion to dismiss this case. One is statutory in nature, the other is in common law in nature. The 3rd issue is an attorney's fees matter that is a matter of statutory construction and is in essence contingent upon the court denying the motion otherwise as to the first 2 issues. The first issue is whether or not the winding down or dissolution of the committee prohibits this action from moving forward. That is a matter of statutory construction. The court is finding that that does not prohibit this case from moving forward. It is denying that motion in that regard. Specifically, this is a question of whether under the statute this winding down or dissolution is allowed. The plaintiff has raised an issue as well about the possibility of continuing contributions, whether in money or in kind. The court doesn't reach that issue. The court more specifically identifies RCW 42.17a.235 sub 8 with respect to the procedures that apply when a committee is being dissolved or wound down. The court is finding that the proper construction of this statute is that when there is no outstanding debt or obligation, that condition is not met when there is a lawsuit such as this that is pending. Based on the mandatory liberal construction that is given to this statute, and given the dictate that courts avoid absurd results, the court is finding that the penalties and enforcement of these laws cannot be avoided by disbanding or dissolving such a committee. There was an argument raised regarding the Moxie Media case and the fact that if there are allegations of intentional wrongdoing, that these issues may nonetheless be pursued against individuals. The court does not find that the law is so limited to intentional misconduct. Also, the court notes that it goes to great lengths to avoid making references to the statutory construction rule that absurd results must be avoided because it is often a last-ditch effort to save a statute, and there are typically other means of properly construing a statute, and it is correct when defense counsel indicates that policy matters are left to the legislature. However, this court finds that the legislature has been properly clear, and the people, through the original initiative, in identifying the policies underlying this statute, and the court finds that the construction of debt or obligation in subsection 235 sub A a construction that this dissolution would prohibit this action would be absurd and would completely undermine, in essence, the purposes of this statutory scheme. and thus the court is denying this motion with respect to that. The second issue is that of the common law doctrine regarding priority. This is a question that has not been squarely addressed by any existing Washington authority. We have a number of cases that come close to it, but do not quite get us over the goal line, so to speak, in terms of squarely resolving this issue. We have the Yakima case regarding the firefighters, where a case was submitted to PERC. The court finds in this case that this is not the same as PERC, given the nature of that forum as one where parties may resolve disputes between each other, similar to a court. That is, in essence, the action of submitting a charge to PERC is the same as filing a lawsuit, and there is some adjudicatory wheels turning by the filing of a charge, so to speak. We have the Freedom Foundation and Washington Education Association case, which is somewhat vague with respect to the facts that underlie that case. The case mentions that the PDC took an administrative enforcement action, and it doesn't say exactly what that is, but it does indicate that the PDC would file administrative charges. Thus, to the best this court can construe that case, it is the filing of administrative charges that is the administrative action that would start those adjudicatory wheels turning in that case. In this case, we have no indication that anything has happened with respect to the PDC taking any adjudicatory action in this case. We have the filing of a PDC complaint. We also have a letter being sent to the defendants in this case, asking that they respond to that complaint. There is no indication in the law or in anything in this record that would be subject to judicial notice that that is anything other than a pro forma automatic ministerial action that happens with respect to every complaint that comes in the doors of the PDC. Even if there were some winnowing of obviously on their face frivolous or inapplicable complaints, it still appears to be the case that the PDC does not exercise any meaningful discretion or otherwise engaging in any adjudicatory action in sending that letter, and there is no indication in this case that any other action has happened with respect to that PDC complaint in this case. Plaintiff's counsel candidly acknowledged that this would be an easier issue if the PDC complaint had not been filed. This court is not quite sure why the PDC complaint was filed, but it doesn't matter because that does not deprive this court of being the primary priority forum in this case, given that no adjudicatory action has occurred in any other forum. Specifically, the filing of the PDC complaint is not the same as the filing of a PERC charge, given the differences between those forums. And thus, this court is denying the motion to dismiss based on that argument as well. Given that the court is denying and rejecting those arguments, the court then must reach the issue of attorney's fees. The court is granting the motion to dismiss the claim for attorney's fees as to the defendants based on the statutory construction of the provisions of the law regarding claims for attorney's fees. The court agrees with defendants' counsel that the appropriate construction is that there is no claim for attorney's fees to be awarded against committees or entities in this context. The statutory scheme specifically references in citizen actions when and how and where fees may be recovered. This court, under the canons of statutory interpretation, dictating that the specific governs over the general, and the exclusion of the references of one thing is the exclusion of another, finds that the explicit references to how fees are recovered in citizen actions limits and identifies those circumstances, and that it is not for these types of cases for this court to be awarding fees against a defendant. And thus, in this case, the court is dismissing the claim for attorney's fees against the defendant in this case. If this case is to proceed and there is a question of the fees that are recovered by the plaintiffs vis-a-vis the state, I am not saying how that is or is not to occur, but that issue is not before the court at this point. The state is not a party in its direct authority and position, and so that is not right for this court to determine. So in summary, this court is denying the motion to dismiss. Mr. Morgan's claims on their merits may proceed in this litigation. The claim for attorney's fees is dismissed against the defendants. Do the parties require any clarification regarding the court's ruling?
Thank you, Your Honor. My request for clarification is really a further request whether the court would consider certifying that the two issues in which you have just denied the motion to dismiss involve controlling questions of law as to which there is substantial ground for difference of opinion, such that immediate review of the order may materially advance the ultimate termination of the litigation. And if I can just explain what.
And actually, I get your request. Right. Before I hear anything else, I'm curious if the other side, with a one-word answer, agrees with that request.
Agrees?
That it should be certified.
No, I don't agree.
And so given that there is not agreement, this is a matter that I routinely see fully briefed and otherwise argued, and I am not going to rule by an oral motion at this time. If there is such a request, I will entertain that being made through our proper local and civil rules regarding motions in civil cases. I understand the basis for your request, and it is not one that surprises this court. But given the procedures we have in place in due process and the desire of this court to be fully informed as to that issue, the court is not going to be entertaining an oral motion, but will entertain one properly noted pursuant to our local procedures.
Let me ask you a question, because I've run into this problem before. I now have 30 days to file a motion for discretionary review. My experience with this is a busy court. It can be very hard to get on the calendar for argument in a time period that allows that certification, if it's going to be granted prior to the date that I am actually having to write a motion for discretionary review.
I will note that we have ample room on the March 2nd calendar, such that if you were to file that in a timely manner before the deadline on the preceding Thursday, that there will absolutely be space for that.
Great.
And that is definitely not going to get filled.
Thank you very much.
I believe that Mr. Whitson and myself have filed notices of unavailability. Mine's from the 24th of this month to March 9, and yours was from the 26th to March 9.
That's true, but I have Ms. Ewan here. Because of the timing issue, I don't know if Mr. Powers is willing to agree, and if you would consider letting us argue the certification issue. I don't think it's that complicated. I understand it's not your normal procedure. It would be a great blessing, I think, at least to myself and possibly to both parties, to not have to go through a whole detailed briefing. I think it's clearly a matter of your discretion. You are now completely apprised as to the strengths and weaknesses of both issues. I guess I would renew that request. Certainly if Mr. Powers doesn't object, I understand if he does, he's entitled to, you're going to let him file a brief, and that's appropriate.
I could alternatively set this at my discretion for next Friday. Understanding that this will limit time for filing of briefs, and there is a 3-day weekend in the middle. Although I do concur with defense counsel, this is not likely to be something requiring voluminous briefing. And so, Mr. Powers, would you object if we were to set this for next Friday and we could pick dates on when different things are filed? To get understanding, it will be very short, the pleadings that are filed.
The Friday is the day I'm flying out. That's going to present. I also have a major matter next Wednesday.
Okay, well, let's strike that. I can do this without oral argument. I can receive pleadings, and we don't have to have oral argument on this matter. How does that sound?
Well, it sounds fine. You know, I would say that, you know, there are, I've submitted discovery requests that have not been responded to either through a request for a 26I conference or any tender. They were due on the 11th of this month. I've asked for a 30B6 designee to be identified, and all of these requests have gone completely unresponded. I really think that getting this you know, on the tracks and, you know, finding out what the reasons were for and maybe now we're essentially arguing the merits, and maybe it's appropriate to hear this now rather than, you know, I think I can probably...
Are you comfortable?
Yeah, I mean, I'm comfortable arguing it,
okay,
just
so
to like move this thing forward.
Given your concerns, I will make an exception and entertain an argument at this point with an oral motion, given the different unavailabilities, the 30 days, and everything else that is happening here. So I will hear your oral motion at this time.
Thank you. The motion is going to be very brief. You obviously can make your own assessment as to whether the order involves controlling questions of law. Obviously, the motion to dismiss, so it clearly does. Whether there's substantial ground for difference of opinion, that's really your judgment as to the potential strength of either of the two arguments that we made. I will say, the committee is defunct. There's a reason why it has not responded to discovery or provided a 30B6 witness. I do not expect the PAC is going to do either of those things or present any kind of defense on the merits to this case. I suspect there will be motions to compel, motions to hold someone in contempt, which you will not have the pleasure, the dubious pleasure of having me in your courtroom, because we can see from the records the amount of money that was paid to my firm before the committee went defunct, and it only goes so far. I think that's going to be a mess, and it's going to give rise to a whole bunch of messy issues, which are not going to materially advance the ultimate termination of the litigation. I think that if Your Honor thinks that there is a reasonable possibility that the Court of Appeals and State Supreme Court in their infinite wisdom might disagree with your assessment out of those, you know, frankly, our firm will continue to litigate those issues because we're, if nothing else, psychologically invested in it at this point. I just think it's going to be a mess otherwise, for all the reasons that you're well aware or can infer from the records that you've seen.
That's a response?
I don't think it's a close call, and I don't think it's a close call because of the 2015 Utter decision. I think that the court, and I think that was an 8-1 decision, was pretty crystal clear when it came to its, you know, we're not going to look and see what amount of investigation that the PDC does constitutes an action. So I think that that's a recent case. It was either unanimous or it was an 8-1, I forget. It's not going to be a close call. The second issue is I don't think this is going to be a terribly complicated case from this point forward. Basically, we have the defendant essentially admitting liability under these circumstances. So the question really becomes,
what was the need for all the discovery then? Well,
the need for the discovery is what the circumstances are. You know, why weren't these things filed, right? Was it because, you know, somebody came down with cancer and you know, was unable to, you know, file these things? That's completely one set of facts that may be true. I'm just throwing out a hypothetical there. I have no idea. Or was it, this was their modus operandi, and they thought, hey, we don't have to file these things. We can hide $70,000 from the public view, and we've got this great idea because we can just disband when, if anyone comes asking for questions. That's on the completely different side of the spectrum from that. So I think right now we're sort of in, to borrow an analogy from the Public Records Act, we're sort of in the Yusufian phase, right? What's the appropriate penalty to be assessed given the circumstances and the reasons behind the failure to make these appropriate filings? So I don't think it's going to be a huge amount of discovery. I think, going up on to, appeal and coming back down, will take a year, when I would think that we could get through this, if defendants actually engaged in the litigation. I think we could get through this in a matter of a few months. I've already tendered a set of written discovery, no response. I've asked for deposition dates, no response. If we can just get this show on the road, we're out of here. And we don't have to go up, do all the briefing up there and then come back down and get this done. We can get this and take the whole case up after a final decision. And also, the fact that we are having these questions dealing with the applicability of attorney's fees, there may be another substantial question that is going to be worthy of review by the appellate court. And so rather than yo-yoing up and down, let's do this entire case and then have the Court of Appeals address it wholesale, and we can really get a determination as to what the law is. I will also like to note that there are 3 other cases I have representing Mr. Morgan as a relator against various political committees. These 3 political committees are also represented by defendant's law firm. And I agreed to stay those cases while we heard this, so we could get a determination from the court as to what an appropriate rule was, whether or not you could dissolve, whether or not that there was a priority of action. And we've now got that determination.
How many of those are before me? At least one is.
One is before you, and I don't know off the top of my head who is.
Judge Murphy has one. I didn't realize there was a third.
Yeah, there's a third.
Okay.
There, yeah.
And I asked that because a different judge can disagree with my ruling, and so.
Happens all the time.
It does. So anything else you want to add at this time?
That's all. That's it.
Last word?
I don't think I need any last word.
Thank you. I'm going to deny the request to certify. The Court of Appeals may have a different opinion on a request for discretionary review, but it is this court's opinion that I believe I agree with plaintiff's counsel that there isn't actually all that much more to do in this case before it can be wrapped up in its entirety with a final determination. And then these issues, along with any other issues that may come up along the way, will be together for a single determination by a reviewing appellate court. Additionally, the court believes that there are indications that there may not be any further action in this court on behalf of the defendants. That remains to be seen whether or not that will actually be the case. The court believes that for the purposes of an appellate reviewing court, that it is beneficial to have additional context in the case when reviewing these types of matters. Additionally, I believe it would be most efficient simply for us to move forward, and then there can be an appeal if there needs to be an appeal. And so I'm denying that request. And I believe that concludes the determination of any matters that we had in this case. Anything else the parties want to raise at this point?
No, Your Honor.
No, Your Honor, thank you.
Thank you. Enjoy your extended weekends. The court is in recess.